objection, my lord, as regards the maintainability of the writ appeal, my lord. Why I say so is, my lord, because, my lord, a writ petition and a miscellaneous petition under 227 both were filed. Now, the 227 petition was against the order passed by the Learned Family Court, and the writ petition was filed against the order passed by the SDO, whereby, my lord, the SDO under section 97, section 100, my lord, my lord, virtually executed the order of the family court. So that was a consequential proceeding, and the main order under challenge was passed by the Learned Family Court. So, my lord, the Uच्च न्यायालय खंडपीठ को अधिनियम, my lord, it specifically says that writ appeal would lie only against orders passed under Article 226 and not under Article 227. So, my lord, although the Honorable Single Judge, my lord, has been pleased to dispose of both the petitions together by a common order.
So, in one matter we remember, we have issued a notice and framed the issue whether this the writ appeal is maintainable before this court.
With due respect, my lord, if my lord may permit, my lord, I have uploaded one full bench judgment and a three-judge judgment by the Honorable Supreme Court, my lord, in the reference column. If my lord would just have a kind perusal of that.
Yes.
My lord, in the reference column, my lord. That is 2017 volume 4, 2017 volume 4 MPLJ 109. FB, my lord, I have mentioned at reference number 13, 2017 FB, my lord. The last paragraph is most relevant, my lord. Para number 18. हाँ, 17.
We may clarify that.
Sir.
Yes.
May I read, my lord?
Yes.
We may clarify that the orders passed by the judicial courts subordinate to a high court, even in criminal matters, when challenged in proceedings before the high court, are only under Article 227 of the Constitution of India. Thus, no intra-court appeal would be maintainable against an order passed by the learned single judge in proceedings arising out of an order passed by the judicial courts, may be civil or criminal proceedings.
Yes.
So, my lord, in this case, my lord, admittedly, my lord, the Honorable Single Judge, my lord, has quashed the order passed by the Learned Family Court, and thereafter, my lord, the order passed by the SDO has also been quashed. So that's a consequential order, my lord. So therefore, I say that the writ appeal, the instant writ appeal, would not be maintainable, my lord, because the Honorable Writ Court has been pleased to exercise jurisdiction under Article 227 and not under Article 226. And my lord,
Yes.
So what you have two orders. May I just point out, Milord, there is a composite order, Milord, which has been passed. One under 226, Milord, and other under 227. Now, first of all, Milord, my submission is the full bench, Milord, that is Shailin Kumar, paragraph 14 to 18, Milord. In fact, Milord, delineates, Milord, just because a particular petition, Milord, stated to be under 227 would not be under 227. Milord, what has to be seen is, Milord, what has been decided by the court. Now, here what has happened is, Milord, that under 226, Milord, there is an order passed by the subdivision officer. There is a writ petition filed. Now, Milord, what they are saying in the writ petition, alleging malefides against me and my, Milord, family members. The issue here is, Milord, regarding custody of a 22-month-old child who was on the run, Milord, with, Milord, her grandparents, Milord, who were facing charge under 304B for dowry there. The mother, Milord, has committed suicide. The boy was taken away, Milord, by the Dada and Dadi, Milord, were on the run for almost 2 months, Milord. We filed a habeas corpus petition before this honorable court. Milord, they were declared absconding, and then, Milord, the child, 22-month-old child, Milord, almost not even two years, was produced before this honorable in the habeas corpus. Then we were directed, Milord, to make an application under the Guardians and Wards Act, Milord, to make an application for interim custody because, Milord, the grandmother, Milord, was on the run. Father is behind bars. He's already arrested. Father, Milord, is behind bars for the past, Milord, almost 5 months.
No, we are not on the facts.
So, Milord, my submission is, Milord, what happened subsequently is they filed a writ petition, Milord, and a 227 petition. 2 petitions have been filed. In the writ petition, Milord, what they're alleging is malefied, saying that my brother-in-law, who's collector Tikamgarh, he has influenced, Milord, the subdivision officer, Milord, to grant custody of the child. So those malefides have been alleged there. Both the petitions were clubbed together. The 227 petition, Milord, as well as the 226 petition.
Order is common.
And common order is passed. Now, I'll point out, Milord, 2 judgments.
Common order, Milord. I will not deny that.
And Milord,
Then we can't segregate.
And my lord,
My lord, why I say so is, my lord,
I'll just
my lord, sorry.
Yes.
my lord, there is a judgment of the Supreme Court 2009 volume 1. My lord, in fact, in the reference column, your lordship would see, my lord, serial number 9. My lord, I have the hard copy as well. If your lordship may have the hard copy.
Yes, we have that.
And I have also pointed.
Yes, we have that.
Yes.
You can fight up. Yes.
So if your lordship would have, my lord, in this, my lord, paragraph 14 and 15, it says when there is a composite order passed, then in that case, my lord, the writ appeal would lie, my lord.
Para 15,
My lord,
14, 15.
14 and 15, my lord. May I read, my lord?
Thus-
In Surdev
thus-
Rai versus
thus-
Ramchandra after reference to,
Thus,
I'm sorry,
para 14.
para 14.
Yes, please. Yes, Surya Dev.
Yes, my lord. In Suryadev Rai versus Ramchandra Rai, after referring to the decisions in Custodian versus Khan Sahib, Nagendra Bora, Lord, these are all 5 judgments, my lord. From aforesaid enunciation of law, it is quite vivid and luminescent that pleadings in the writ petition, nature of order passed by the learned single judge, character and contours of the order, direction issued, nomenclature given, the jurisdictional perspective in the constitutional context are to be perceived. It cannot be said in a hyper-technical manner that an order passed in a writ petition, if there is assent to the order emerging from inferior tribunal or subordinate court, has to be treated all the time for purposes to be under Article 227 of the Constitution of India. Phraseology used in exercise of original jurisdiction under Article 226 of the Constitution in Section 2 of the Act cannot be given a restricted and constricted meaning, because an order passed in a writ petition can tantamount to an order under Article 226 or 227 of the Constitution of India, and it would depend upon the real nature of the order passed by the learned single judge. To elaborate whether the learned single judge has exercised his jurisdiction under Article 226 or under 227 or both would depend upon various aspects, and many of facets have to be emphasized in the aforequoted decision of the apex court. The pleadings, as has been indicated herein above, also assume immense significance. As has been held in Suryadev Rai, a writ of certiorari can be issued under 226 Article 226 of the Constitution against an order of a tribunal or an order passed by the subordinate court. In quintessentially, it cannot be put in straitjacket formula that an order of learned single judge that deals with an order arising from an inferior tribunal or the subordinate court is an order under Article 227 of the Constitution of India and not an order under Article 226 of the Constitution. It would not be an overemphasis to state that an order in a writ petition can fit into subtle contours of Article 226 and 227 of the Constitution in a composite manner, and they can coincide, coexist, overlap, imbricate. In this context, it is apt to note that there may be cases where the learned single judge may feel disposed or inclined to issue a writ to do full and complete justice, because it is to be borne in mind that
in the writ petition, the custody of the child is given to,
my lord, it is given, my lord, to the maternal grandparent, Nana Nani ko diye. I am appearing for them.
and you are.
I am appearing. Sorry, writ, my lord, in the family court, my lord.
वो दादा दादी के लिए किया है
Sir,
नहीं, दादा दादी को नहीं है.
नहीं अभी उसके पास किसके पास था
अभी प्रेजेंटली नाना नानी के पास है, मामा और नाना.
अच्छा नाना नानी के पास है
जी.
और सिंगल बेंच गिवन दादा दादी
sir.
जी. So family court handed over custody to me. Against that, my lord, they had filed, my lord, the miscellaneous petition. Lord, may I just also point out one.
no but age of the child is
my lord,
22 months.
Lord, now 24 months. 2 साल का. 2 साल.
2 साल का
2 साल. I may just point out, my lord, 2 points, my lord. If your lordship may just have the learned single judge's order for a moment.
चलो इसको सुनते हैं अपील
Lord, my respectful submission is subject to what my lords, my lord, flows from my lords.
Yes.
The judgment being read over by my friend, my lord, it would not be applicable. Why, my lord?
Oh.
Because in these are the cases, my lord, whereby, my lord, the writ petitions are drafted by saying writ petition under Article 226/227.
Oh.
So, my lord, in those cases, my lord, this judgment is interpretation, my lord. Subsequent to this judgment, my lord, larger bench judgment, my lord, 3 judges bench judgment of the Honorable Supreme Court, my lord, that I have uploaded, my lord. My lord, the Honorable Supreme Court has been, sorry.
one petition he said he filed under 226, another is 227.
Well, yes, my lord.
Huh?
My lord.
Right? Or the filed the one petition under 226/227.
No, my lord. One was under 226 specifically, one was under 227 specifically.
Right.
So, my lord, the 227 petition was essentially challenging the order passed by the learned family court. Now, that's the main order, my lord.
But on this 226 petition, you have no any grievance.
Pardon, my lord?
Past order is under 226 petition, you have no grievance, right?
Because
appeal is maintainable before.
appeal is maintainable, my lord.
But on 227, You have an issue.
My lord, why, my lord, I say, my lord? Because if the 227 order, my lord, the order of family court goes, my lord, then the 226 petition whereby the order of SDO is under challenge, my lord, it does not have any effect, my lord. Because because they have executed the order of the family court.
But listen, you should have raised this issue before the family, these are the two petitions. One is 226, one is 227. Common order not to us, both to be dealt separately. If common order is passed, how can we segregate?
Let me just make one
But,
submission.
my lord, just one more, sir. He was living with us, with the paternal grandparents and his mother and father.
Where mother committee society?
My lord, in June 24. My lord, I have mentioned it in the writ petition, my lord.
Not the fact, when I just have page 42 of the writ petition, I just point out two factual clarifications. Both the petitions were filed by my learned friend.
Yes, my lord, I am not denying that fact.
Both the petitions were filed by them, they got them clubbed together. And my lord, they alleged malafide
Now-
of the writ petition.
Now they are raising issue.
Now they are raising an objection. Now, my lord, may kindly up.
My lord,
Now, my lord, what they are
that
doing
was
is-
never the intent, my lord.
Just point out, they got both the petitions clubbed together. They raised allegations of malafide in the writ petition. Actually argued that, my lord, before the learned single judge, saying that, my lord, respondent number 4 has personally made a party saying that he is collector of Tikamgarh, he has influenced, my lord, the order. And now, my lord, when we are saying, my lord, that this is something which has been alleged by them in the writ petition, and both have a common order passed or composite one single order. Now they're trying to segregate it by saying, my lord, that 227, my lord, and 226 is a consequential order. They chose to have both the petitions linked together, argued both the petitions together. And now they are saying, my lord, that it should be segregated, it's not maintainable.
My lord, with due respect, my lord, I do not say, my lord, that it be segregated. What I'm saying is, my lord, that because the order of the family court was quashed, therefore the honorable writ court, my lord, has been pleased to also quash the order of the SDO, my lord. Had the order of family court not been quashed by the honorable single bench, my lord, there was no need to quash the order of the SDO.
The WP 36211,
Yes, my lord.
that was under 226,
226, my lord.
226.
In that petition, my lord, the order of
In 226, challenging the order of the SDO.
SDO, my lord, whereby, my lord, he has executed the order of the family court. So the main order was under challenge was the order of the family court, my lord. In the miscellaneous petition.
That is MP 6420.
My lords. My lord, if my lord may permit, my lord, may I also point out on the merits of the case, my lord.
And this was 227.
Yes, my lord. So, my lord, अगर वो 227 मतलब जो अगर फैमिली कोर्ट का ऑर्डर क्वॉश कर दिया है कोर्ट ने, इसीलिए सर द ऑनरेबल सिंगल बेंच हैज बीन प्लीज्ड टू आल्सो क्वॉश द ऑर्डर ऑफ द एसडीओ. अगर फैमिली कोर्ट का ऑर्डर क्वॉश नहीं होता तो सर एसडीओ के ऑर्डर क्वॉश करने का कोई जरूरत नहीं थी सर, क्योंकि फैमिली कोर्ट का ऑर्डर खत्म कर दिया है, इसलिए कॉन्सिक्वेंटली सर एसडीओ का ऑर्डर.
This was just take down, notice issued, consultant accepts notice on behalf of the respondent number. You are for respondent number?
I am for respondent number 1 and 2. My learned friend is for respondent number.
For number 6.
Counsel for respondent number 6 has taken preliminary objection that the present appeal is not maintainable as the order is in WP MP number 6420224, which was filed under 227 before the learned single judge, 227 of the Constitution of India. Stop.
I am
Counsel for the appellant had pointed out that both the petitions mentioned above filed. No, the respondent filed, the said respondent filed WP number 36211/2024 under 226 of the Constitution of India and MP 6420/2024 under 227 of the Constitution of India. However, during the pendency before the learned single judge, at the request of the respondent 6, they both were clubbed, and in both the petitions mentioned above, common order has been filed. Stop. In view of above, the list after 4 weeks, parties are directed to file written submissions with case law relied upon.
Sir.
Why are you making issue of child? We'll
Malad-
decide
Malad-
when child is there, let
Oh,
child.
my lord, therefore I'm saying, my lord, right since the birth of the child, my lord,
Sorry.
the child was with the paternal grandparents, my lord.
I'll demonstrate.
No, I'll,
Just since birth child was with
the paternal grandparent, दादा दादी के पास था सर.
दादा, तो दादा दादी के पास है तो दादा दादी के पास ही रहेगा.
तो सर उन्हीं के पास था, वो तो फैमिली कोर्ट ने सर बाय एन इनकरेक्ट ऑर्डर, my lord.
जस्ट handed over or
My lord, and the SDU.
एक second. कब hand over हुआ?
My lord, on the, my lord, the date, my lord, that is on the date
16/11,
16/11, my lord.
right? 16 हो गया, एक महीना हो गया, बच्चा कंफर्टेबल हो गया होगा.
Sir, my lord, that situation, my lord, no one has that, my lord.
I filed
No,
documents, videos, everything I filed.
My lord, the manner in which the child was taken and the manner in which the order has been passed would just have a perusal of the order passed by the learned family court for just for a moment, my
The
lord.
manner child has taken, you have not challenged that.
My lord, that is under challenge in the writ petition. That is exactly what is under challenge, my lord. And therefore, my lord, I have alleged malefides because the brother-in-law of the deceased is the collector, and therefore, my lord, using force and pressure and the police force, my lord. My lord, the child has been taken away, my lord. I have filed a pen drive containing the videos.
फैमिली कोर्ट ने जो कस्टडी दी नाना नानी को,
सर, और उसका ऑर्डर सर एग्जीक्यूट करते हैं एसडीओ, फैमिली कोर्ट का ऑर्डर, who has no jurisdiction, my lord, under section 100 CRPC.
right?
And my lord, he, by using force, my lord, on the very same day, my lord, 50 police people enters into my house and they have taken the custody.
अभी बच्चे को रहने दो.
My lord, would just have a perusal, my lord, and two judgments of the Honorable Supreme Court, my lord.
We'll see the file the judgment.
My lord, it is on record, my lord. Everything is on record.
So therefore, we'll hear this thereafter.
Obliged.
Next matter.